What you know, alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Monday, April 21st. Hope you're having a good day so far. We have a busy day coming up. I'll be live streaming jury instructions, closing arguments, and verdict watch in the Lori Daybell trial. I'll put the link in the description here to that live stream and also out on all the socials. I'm back in Greenville, by the way. Feels really weird not being there for the last of it, especially after being there for 2 weeks. But my Grammy's back just really isn't much better. And my parents are out of town, so I wasn't going to leave her without one of us here. It's all good. I'll be watching live with you guys, and my heart is definitely in that courtroom in Phoenix today, hoping for justice for Charles Vallow. The other thing I want to talk about before we jump into today's episode is the Karen Read trial. I really haven't covered it here on the channel, although I have followed it. And I've had a lot of people ask if I would do the daily trial recaps and live stream on the channel. So I thought about it over the weekend, and I am going to do daily recaps starting tomorrow, where I will break down the day's best testimony in an hour or less without commentary or opinion. So that way you can keep up with the daily happenings in that trial. The problem with covering this trial is that it's expected to last 6 to 8 weeks. The last trial for Lori Daybell in Arizona starts June 1st for openings, and I do plan to be out there for that first week. So if this trial runs really long, there could be an issue at the very end of it. We'll just have to figure it out when we get there. So having been in Arizona for the last 2 weeks, I really haven't had a chance to stay current on any of the cases we're covering, but there were several rulings that came down in the Bryan Kohberger case. We're going to go over those now. The first ruling was the order on family members in the courtroom. The judge says the court is sensitive to the fact this is anticipated to be a lengthy trial, and the defendant would like the support of his family. The court also understands and empathizes with the concerns that parents, themselves having done nothing wrong, would have, and the trauma they would endure because their child is being accused of and tried for capital homicide, and their desire to be present for their child. Further, the scope of his family's testimony is likely going to be limited. So the court is going to require the state submit for an ex parte in-camera review, and also a list of the Kohberger family members they intend to call at trial, as well as the purpose for calling each of them. The state must also identify family members that cannot be called very early in his case in chief and articulate why the exclusion of the family members is necessary under Idaho Rules of Evidence 615, especially given the unprecedented publicity of this case, which has made much of the evidence available to those who wish to know, including the proposed Kohberger family witnesses. By the way, Idaho Rules of Evidence 615 is at a party's request. The court may order witnesses excluded so they cannot hear other witnesses' testimony. The state has until April 25th to submit these materials, and a decision will be made at or before that pretrial conference on May 15th. Moving on to inflammatory evidence. The judge says the defendant hasn't specified what evidence he wants kept out or otherwise defines as exceptionally inflammatory. Issuing an order as requested would lack any substance. It would simply require the state to abide by evidentiary rules, as well as the prosecutor's responsibility when presenting their case. Prior to seeking the admission of this evidence, the state is required to provide copies to the defendant. If the defendant believes the evidence is cumulative, unnecessary, or otherwise prejudicial, he can take the matter up outside the presence of the jury. As far as the defendant's motion in limine prohibiting the state from using the term murderer, that's denied. And the ruling says the state acknowledges it would be improper to refer to Bryan as a murderer. And the use of the terms psychopath or sociopath, that motion was granted. The state does not intend to use these terms at trial. For improper death penalty comments, the state asked the defense be precluded from making improper comments about the death penalty, specifically that the state is attempting to kill the defendant, which counsel has stated in past hearings. The judge denied that and said he's unwilling to enter an order requiring defense counsel to act professionally and comply with existing rules. The next one is the order on the state's motion in limine regarding neuropsychological and psychiatric evidence. This is regarding his diagnosis of autism and obsessive compulsive disorder, as well as his demeanor being a flat affect, a piercing stare, and his inability to react to photos that may be shown during trial. The defense is worried that might look like a lack of remorse. The judge ruled that evidence of autism to explain his demeanor is only relevant if he takes the stand, but defense experts can talk about it for rebuttal arguments. How would that work? The defense could use this regarding the night drives Bryan says he took, and an expert could testify this is due to insomnia, and this was the go-to for Bryan in regards for that. The judge did note he had never seen any odd behavior from Bryan during the many hearings they've had. This can be addressed in voir dire by asking potential jurors if they can be impartial and not judge Bryan based on his behavior at counsel table. As far as the defense wanting to call an expert to say Bryan could not have committed the murders because of a developmental coordination disorder, that is denied. The judge said none of their experts have said he has the disorder or given an opinion about his ability to commit the murders. As far as the jury hearing about his OCD, the judge is going to reserve ruling until trial because the state may argue he was trying to destroy evidence while at his parents' home in Pennsylvania shortly before he was arrested. The judge said by way of example, he notes that just prior to his arrest, law enforcement saw him wearing gloves and handling baggies. Believing he was destroying evidence, law enforcement abbreviated its knock and announce procedure. If the state introduces this or similar evidence at trial, the defendant asserts that evidence of his OCD would be relevant rebuttal to offer another explanation for his behavior. As far as using the term bushy eyebrows, the judge ruled the surviving roommate can use the term when referring to the man she saw at the time of the homicides. He said this is highly relevant and it's also been remarkably consistent with statements the roommate has given. While she did not mention eyebrows in her initial interview, she thereafter identified the bushy eyebrows on multiple occasions as something that firmly stuck out in her mind. Although she might have been intoxicated, tired, or questioned her memory, the consistency of her descriptions suggests a high degree of reliability. That description might or might not implicate Bryan, and that is for the jury to decide. The state, they're wanting to bring in that selfie that was taken just hours after the murder to show his appearance. As far as the white car on surveillance, the judge ruled the state can refer to surveillance video showing the white suspect car as a match to Bryan's Elantra. The judge said investigators used their training, expertise, and experience to come to this conclusion, and the jury can weigh both sides. As far as using the terms touch DNA and contact DNA, the defense wanted those terms to be excluded. The judge said he's worried if he banned a word and it's accidentally used during trial, that could end in a mistrial. He urges counsel to avoid using these terms, but says he will not police experts in the field. Moving on to a ruling on an alternate perpetrator. The judge said the defendant cannot merely show another person committed the crime. There must be direct or circumstantial evidence linking the other person. In order to avoid a delay at trial, the defendant must present the offers of proof no later than May 14th, so that matter can be addressed at the pretrial conference on May 15th. So the ruling on that is reserved. The motion in limine to exclude Amazon click activity evidence at trial. The judge says this evidence is highly relevant. A K-bar knife sheath was found lying next to the body of one of the victims, all of whom were stabbed to death. The defendant's DNA was found on the knife sheath. Records from an Amazon account registered to Bryan's name and email show that a purchase of a K-bar knife and sheath was made from the account approximately 8 months prior to the homicides. Click activity on the same account shows the customer also viewed pages associated with the K-bar style knives at the time and in the week following the purchase viewed pages associated with the shipping progress of the knife and sheath. The product was shipped to Bryan at his family's address in Pennsylvania. After the homicides, activity from the same account showed the user navigated pages related to the deletion of account activity, and a week later viewed pages associated with a K-bar knife and sheath. This evidence establishes a significant connection between the defendant and a K-bar knife and sheath. The judge said Bryan is free to challenge this evidence through cross-exam, and it will be up to the jury to consider all the evidence and decide whether Bryan was the clicker. Motion denied. As far as the AT&T timing advance records, the state was asking the defense be prohibited from making any reference to the absence of AT&T timing records related to Bryan's cell phone. The state contends it never received those records from AT&T. They will allow the defense to voir dire FBI Special Agent Balance, asking if he ever received the records. If he denies receiving them, the defendant cannot explore the matter further. Given the lack of any factual basis to support his position, the state is hiding them. The judge granted the state's motion to allow a demonstrative aid into trial. That is a 3D model of the King Road residence. The state filed a motion to preclude the defendant from offering any evidence in support of an alibi other than from the defendant himself. The judge said this issue is premature and is denied, but notes the defendant hasn't provided an alibi. And if he does unearth an alibi, he would need to immediately make the state and the court aware. The last ruling was the prior traffic stop. The state wants that in to show the defendant's identity, vehicle ownership and control, as well as address and phone number. The judge will allow this video in. However, there is one part that has to be redacted, and that is where Bryan asked the officer why he needed his phone number. And those are the latest rulings in the case. I will check to make sure I haven't missed any. Again, the next hearing for Bryan Kohberger is May 15th. That is it for this episode. Hope you guys have a good rest of your afternoon, and we will see you soon.